I'm Doug Lichtman, and this video introduces trade secret law. Trade secret law can cover a wide range of things. I put some examples up: a customer list, a secret recipe, your marketing plan. Basically, it's an area of law that can cover, well, secrets, information that's important to your business, has economic value, you're trying to keep it secret, and all of a sudden you can bring it into the system and get some protection. Trade secrets does overlap to patent law sometimes. So you might have an achievement and you think, maybe I'll send it to patent law, maybe I'll keep it as a trade secret. And as we dig into these areas of law, you'll get a sense of some of the trade-offs there. To get us started, let me offer a few kind of high-level points about trade secret law. And the first one I want to point out to you is that trade secret law is traditionally state law rather than federal law. The Copyright Act is a federal statute. The Patent Act, again, federal. Trademark law is actually done on both levels, although a lot of the hard work is done at the federal level. But for trade secret law, we largely focus on state law. There is, in fact, a federal provision also. It's called the Defend Trade Secrets Act, but it was modeled after the state law and picks up on almost all these themes we'll explore as we look at the state rules. To do the states, well, it'd be hard to do all the states in a video, although that might be fun. And so instead, the way I'm going to cover the state rules is by looking at the Uniform Trade Secrets Act. Uniform acts are kind of proposed legislation written by bunches of experts, where experts in the area, here at Trade Secret Law, they kind of get together and say, if we were writing a rule for a state, here's the rule we would write. And they try to write a really good model law, and then they encourage a bunch of states to please choose that law and adopt it. And in trade secret law, that process has worked really well. We have this Uniform Trade Secret Act, and almost every state has modeled the state rule after this proposed Uniform Act. And so what I'll do in the video is use the Uniform Act to show you the big moving pieces, the big parts of trade secret law. And then obviously, if you're having a fight in Nebraska, you want to double check Nebraska's specific law to make sure there's no deviation that's relevant. Under the Uniform Trade Secret Act, one of the most important pieces is the definition of what is a trade secret. And here's what the Uniform Act says. The Uniform Act says that a trade secret means information, including a formula, pattern, compilation, program, device, method, technique, or process. Information that one derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by, proper means by, other persons who can obtain economic value from its disclosure or use. Lots of words there. A trade secret is information that derives independent economic value from kind of being secret. Then the second piece, it also has to be the subject of efforts that are reasonable under the circumstances to maintain its secrecy. The act then goes on to define what it is to misappropriate a trade secret. That is, what does it mean to take a trade secret at a moment when you shouldn't? And misappropriation is broken into some parts. Part one, misappropriation is defined as the acquisition of a trade secret by a person who knows or has reason to know that the trade secret was acquired by improper means. So one piece is you're getting the trade secret, it belongs to somebody else, and you're acquiring it, and you know or have reason to know that the way you're getting it isn't legitimate. This implies, of course, that there are legitimate ways to get someone else's secret, and of course there are. Think, for example, about reverse engineering. I look at your product, I study it, and I begin to understand how it works. That might be a beautifully legitimate way to go ahead and get the information. The Uniform Act says misappropriation, the bad kind of getting it, misappropriation is acquisition when you know or have reason to know that you're using an improper pathway. Piece one, or the disclosure or use of a trade secret of another without express or implied consent by a person who, and then a bunch of choices. So you're disclosing it, you don't have permission, and you either A, used improper means to acquire it, B, at the time of your disclosure, knew or had reason to know that the secret was derived from a person who used improper means, acquired under circumstances when there's a duty to keep it quiet, and so on. Or C, before a material change to his or her position, knew or had reason to know that it was a trade secret and that knowledge of it had been acquired by accident or mistake. And put all these words together, what are we doing? We're saying misappropriation is there is some secret out there. Economic value, someone tried to keep it secret, there is some secret, and you either acquired it wrongly, so you acquired it at a time where you knew or reason to know, you shouldn't have, or you disclose or use it, and you do that when you know that it was improperly acquired. You do that at a time when you know that it was derived through someone else's breach of a duty. You do that at a time when you know it was acquired through some other bad circumstance, and so on. We're building a lot of moving parts into this definition to say there are trade secrets and you might get in trouble for taking them, acquiring, disclosing them, you didn't acquire it, but you disclose it and you shouldn't have, using them, and we keep looping back to it all depends on how you got it. How did the secret get to you? You're disclosing it, and when you disclose it, did you know that you probably shouldn't have had it in the first place? It's that kind of intuition, a rich articulation of all the kinds of paths that might bring secret information to you, and then you acquire, disclose, or use. The Uniform Trade Secret Act also then defines improper means. It says improper means, so ways that the secret might have been acquired that are no good. Improper means include theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy, or espionage. And kind of pull all that together, we're really defining 3 vocabulary words to help us talk about this bad act. We need a trade secret. That's the first definition. Something of economic value that gets its value from being secret and is being protected as a secret. Someone's taken precautions. We have a trade secret. Then it was misappropriated. It was taken. How? By improper means. And now misappropriation builds in, again, this richness of acquiring, disclosing, using. It was misappropriated. It was used in some way. It was moved in some way. But there was an improper act in the chain. That's the improper means. It was stolen, then you disclosed it. It was gotten by bribing someone, then you used it. We need all 3 definitions to really talk about the circumstances where this is a problem. And obviously we're implying that there are a bunch of circumstances where it's not. It might not be a trade secret, for instance. It might be a secret, but it might not qualify because it didn't have an economic value. It might not have been misappropriated. Maybe you got it in a permissible way, proper means. Maybe you got it in a way and you just didn't know at the time that there was something wrong with the way it came to you. We have all of these words to help us begin to tease out when this will be actionable and when it won't. Some background, I told you that it's state law, and so I pivoted over to the Uniform Trade Secret Act to give us some vocabulary to think about. The next thing I want to point out to you is that more than one person can own the same secret at the same time. Imagine I'm like a real estate agent in Beverly Hills. My trade secret might be my information about the families who live in the couple streets of interest. I know how old the kids are, which helps me understand when they might need a bigger place or when the family might want to downsize. That's information has economic value. It's not generally known. I'm going to try to keep it secret, right? That might be my secret, but it might be that another real estate agent in the same community has pretty much a similar list. They also know this group of families. They're also watching the age of the kids. That's fine. We might both have the same secret, and yet it still might be a trade secret. It has economic value from not being generally known, even though I know it and the other real estate agent knows it too. More than one person might own the exact same secret. That's okay. Second thing I want to point out is that this is an important part of intellectual property protection. We'll talk in other videos about patent, copyright, and trademark, but trade secret is really a big part of just everyday business. Even big companies that are patenting their biggest, most expensive, world-changing achievements, they still might have a bunch of stuff that they're not patenting, that they're keeping as secrets. They might even have some things that are really important to the business that they're keeping as trade secrets. Small players who don't want to spend a lot of money in the patent system, they might have trade secrets. Folks who do things that aren't really patent eligible, like my example in real estate, they've got trade secrets. When you look around at businesses, Almost every business has at least some information that's falling into this legal regime. It's a really important part of the overall ecosystem of intellectual property. I put up some examples. Again, the customer list might be a trade secret. Your recipe might be a trade secret. Sometimes the design of some piece of clothing, like you're doing fast fashion, and you quickly have sketched it up and you're going to go right into production. And by the time the patent system would have said hello to you, it might be out of style already. That might then become something you do in trade secret law instead. Keep it secret, then roll it out and quickly capitalize. I think there are countless examples of information that companies think of as my trade secret. Big picture ideas, we know that this is state law. We know that lots of folks can hold the same secret. We know that it's an important part of the IP ecosystem. I want to add that trade secrecy lasts as long as the secret lasts. Kentucky Fried Chicken would brag about its secret recipe. And you know what? It can be in the trade secret system as long as it is truly still a secret. The formula for Coca-Cola has been a secret for a very long time. It's sugar, very long time. As long as the secret lasts, you can stay in this system. That's kind of unlike copyright, which is a set duration, patent law, which is a set duration. Not here. If it's a secret, if it has ongoing economic value, if you're trying to keep it a secret, remember that was part of the definition, economic value, and it's the subject of reasonable precautions, as long as you do those things and it's working out okay, it's a secret. I always like to remind people that trade secret law is a close relative to some other folks we know. I listed 3 here on the slide. One thing that's a close relative to is the idea of keeping secrets in general. So trade secret law is the law to protect you when you're trying to keep a secret, but often we just keep the secret. Indeed, maybe it's a bad day when I have to call the lawyers and ask about trade secret law because it means that my efforts to keep things secret didn't work out. I keep lots of secrets, it turns out, and as long as those secrets are secrets and they don't flow into the general knowledge, my rivals don't find out about them, right? That's secrecy. Trade secret law is then the legal fallback. When that fails you, you can raise your hand and come get some help. It's a close relative to keeping secrets in general. It's also a close relative to these laws against improper means. You might have been thinking as I read that bit of law to you that, hey, your trade secret law says you can't get a secret by breaking and entering, by bribing people, by theft. And you thought to yourself, well, I'm not supposed to do those things anyway. There are laws against breaking and entering. There are laws against bribing people. There are laws against breaking contracts and all the rest. And that's true. I think trade secret law is related to those things. We point to those things that we already frown upon, and we say if you use those things to get a secret, that is a trade secret violation too. Note, by the way, there are going to be some things that are improper from a trade secret perspective that might not be improper in other areas of law. An example that comes to mind is like dumpster diving. It might be that when you throw something in the garbage that you lose all rights to it. It's not illegal to go through someone else's garbage. A little gross, but not illegal. Whereas in trade secret law, we might say, no, that's improper. We don't want to see that. So there are going to be some mismatches, but overall, again, close relative. Trade secret law is leaning into these same things and saying, no, these are not the ways we want information to flow in the world. Last one I list in my slide is confidentiality agreements. You'll often be asked in business to sign a document that says, you're about to tell me something, I promise to keep it confidential. I won't share it with others, I won't use it for other purposes, things like this. Again, I see that as a close relative. Indeed, often in trade secret law, the way I protect my secret is by making counterparties sign a confidentiality agreement. I tell them, I'm about to show you a secret, acknowledge that, promise to take good care of it. So trade secret law is related to these things, the idea of keeping secrets in general, the laws against improper means like breaking and entering, and confidentiality agreements. But it's more, and this is indeed why I make the list. Trade secret law isn't redundant to those things. One reason is that trade secret law is going to protect you even when your efforts fail. So is it just like secrecy? No, because secrecy fails you sometimes and then the secret's out. Trade secret law says if your secret got out, you might be able to come to us and we'll help you. So one point of distinction is this: it protects you even when your efforts fail. Another point of distinction is that this law is against what we'd think of as third parties. They're not technically third parties, but the idea is if someone breaks into your place of work, they smash a window and steal a document, the rules against breaking and entering would go against that person. But trade secret law says, let's keep an eye and see if that information flows to somebody else, and we'll go after that somebody else also. I'm calling it third party. It's not really third party, it's more parties. But a lot of law goes after a direct bad actor. You stole, you broke your contract, you accepted a bribe, and those folks, I get it, direct law needs to go after them. But trade secret law recognizes that might be the first step in a process that revealed information, and trade secret law polices the flow of that information more broadly. Other people, people who acquire, disclose, or use, knowing about, for example, those bad acts. Last piece is that trade secret law has different remedies than these other areas of law. We have rules against breaking and entering, against breach of contract, and the like, but the remedies under those rules are tightly tied to what those rules are about. If you break and enter, for example, we have rules, well, I guess you might even go to jail, great, but trade secret law is looking and saying, well, wait a minute, what do we need to do now to solve the information problem? Do we need to have an injunction that stops the use of the information? Will we impose cash damages that reflect the value of the information? The remedies might be much different, much broader, much more powerful. The other areas of law are speaking to what they're speaking to and have remedies for those things. Trade secret law is thinking even more broadly about the flow of the information. So while trade secret law is related to all these things, it's importantly different. I want to point out two purposes of the law and help us think about it before we dive into the details. One purpose of the law is to reduce wasteful precautions. And let me play this out for you a little bit because I think it's a really interesting and important insight. So to qualify under trade secret law, you have to have a trade secret. And remember, what that means is economic information not generally known, and you've done reasonable precautions. You've tried to keep it secret. And this is an interesting feature of the law. We ask you to take precautions. And we say, if you've taken reasonable precautions, that's enough. At that point, we'll protect you. If you do a reasonable thing and it fails you, call us, the law, we're going to help. And I think one idea here is that we don't want people to take unreasonable precautions. And they might. Right? If we weren't protecting them and you had some information you really cared about for your business, you might lock it in a safe, write it in code, be really, really insanely careful about which of your employees get to see it, be reluctant to use it on small business projects, only the big ones. You might do things to keep your secret effectively. And trade secret law kind of says you don't have to go that far. Take reasonable precautions, but we want to allow you to not do unreasonable precautions. Don't overdo it. We want you to make good use of the information, and we don't want you to spend all your money on security guards and locking doors and security badges and pits of snakes that people have to jump over. No, we want to be reasonable. And it's an interesting point about law more generally. Sometimes we protect things not because we want to protect them, but because we know that if we don't protect them, you will. An application here, just in kind of normal life, is privacy. Think, for instance, about information that we want to keep private, maybe information about gender, sexuality, things in this category. We might feel like, gosh, we don't want other people to know those details about us. And you might say, society would be better off if all of us were forced to be upfront about those things. If we all had to kind of wear that information on our sleeves, maybe we'd suddenly realize that, 1,000 flowers bloom, there's lots of wonderful ways to be a good person, and chill, everybody, right? Don't be so judgmental on this set of issues. It might be we'd be in a better world if all of us had to reveal that information. We protect that private information anyway, because we understand that if we don't, you would. You would be nervous, for example, say you go to your doctor in a world where we didn't have good privacy rules. You might lie to your doctor. You might have information you really should share in order to get good medical care. Information that you should tell your doctor so your doctor can put an arm around you and help you in a million ways. In a world where we didn't have privacy rules, you might not. You might want to protect yourself. And so we have rich privacy rules, maybe because we think it's great to have all that information stay private. I don't think so. But maybe because we know either way it's going to. Either way, you're going to want to keep it private. And so knowing that, it's less expensive to the world if we have a law that protects it versus not protecting it and putting you in the bad spot where you have to protect it yourself, so you lie to your doctor. Privacy rules on that telling reduce wasteful precautions. Here, very concretely, because there are privacy rules, you can be honest with your doctor. We don't have to lie to our doctor to maintain our own privacy. The law will do it for you. And I think there's a piece of that in trade secret law, right? Whether or not I like you keeping a certain secret, I might want to protect you because otherwise you're going to invest in precautions anyway. So I might say, never mind, don't lie to your doctor, don't lock it up so tightly. The law will protect you. One story for trade secret laws that reduces wasteful precautions. I don't know how effectively it does this. We'll talk about it in a later video, but one of the big ideas here is this idea. The second explanation for trade secret law, which I'm confident does work, is that we do encourage investments in certain kinds of information. There's information that the patent system, the copyright system, the trademark regime, they don't encourage. But trade secret law steps in and does. And this is a very standard IP story. If I value works of authorship, I want to give you a copyright to encourage you to create them. If I value certain inventions, I want to give you a patent to encourage you to invent them. And here too, if I value this type of IP, customer lists, recipes, whatever this stuff is, I want to give trade secret law to encourage you to create it. That's the second story, and I think that one easily explains lots of the law. The first one's intellectually really interesting, but as you'll see, I don't know if it really works. I don't know if we really encourage people to reduce the precautions they otherwise would take. Maybe, we'll see, but we certainly are encouraging investments in secrets. All right, that's our introductory video. Big ideas here, I think. We introduced the state law, the Uniform Trade Secret Act, the vocabulary there of what is a trade secret, what does it mean to misappropriate, to kind of take it wrongly, and to fill that in, we introduced the idea of improper means, certain ways that we really do frown on. Then we did some of the big ideas of trade secret law. More than one person can have the same secret. Secrets last as long as you maintain the secret. And then ultimately we came here at the end to talk about, well, what's this law doing? Maybe it's reducing the pressure you feel to maintain secrets, to invest in those precautions, because you know we got your back. And for sure, it's encouraging investments in these types of ideas. All right, we'll come back in a later video and dig into some of the details of trade secret protection.